Okay, so we are good to go on YouTube. And with that, everyone, welcome. Welcome to Family Law Now After Hours. So today's topic is divorce in the family home. Can you keep it? For many separating couples, the family home is the most emotional as well as financially significant asset. And whether you want to stay, you want to sell, understanding your rights and options under Ontario law truly is essential. For those joining us via Zoom, you may use the Q&A feature to submit your general comments or questions about this topic. However, for specific questions about the details of your family law matter, please contact our team directly. We won't be answering any questions as it relates to specific matters. The purpose of the series is to discuss general information on separation, divorce, and family law matters, and any information provided here should not be construed as legal advice. As always, stay tuned until the end as we will be sharing how you can schedule a free initial consultation with one of our lawyers here at the firm. Now to introduce our panelists for the day, we have Maria. Maria graduated from the University of Ottawa French Common Law program back in 2017. She joined RPB Family Law Corporation in May of 2022, and her focus ranges from negotiated settlements to high conflict family law disputes that often result in litigation. She regularly participates as a judge in various mooting tournaments and has been an assessor for the LPP program for the past year. Maria is trilingual and speaks English, French, and Romanian. Outside of the office, Maria is an avid baker, enjoys watching crime documentaries and movies, spending time with her family and dogs, and traveling. We also have Alyssa. Alyssa brings a holistic, compassionate, and strategic approach to family law, focusing on creating effective and healing solutions for deeply personal legal matters. Her diverse background includes studies at the University of Toronto, an honors LLB from the University of Leicester, and professional experience across family law, civil litigation, criminal law, and municipal prosecution, culminating in her call to the bar in 2025. Known for her investigative mindset and strong sense of justice, Alyssa is driven by fairness, equity, and desire to help clients build sustainable futures out of challenging circumstances. Clients value her empathy, advocacy, and clear, practical legal advice, and trust her to protect their rights while navigating their matters efficiently and thoughtfully. Then finally, you have myself. I am a compassionate family lawyer driven by a deep desire to support families through challenging times. With a background in commerce, I bring strong negotiation, analytical, and critical thinking skills to my legal practice. During my articling period, I gained confidence in handling a wide range of family law matters. I emphasize active listening, clear communication, and empathy, fostering a comfortable environment for clients. I am certified as a collaborative lawyer with the Ontario Association of Collaborative Professionals, and thus I offer clients an alternative dispute resolution approach to avoid court. Outside of work, I am a dedicated Toronto Maple Leafs fan, an LA Rams fan, and enjoy playing hockey and watching comedy movies. So that is your panelist for today. I am now going to switch it over to Maria. Maria, how does Ontario law treat the matrimonial home? Because there's so many exceptions, there's so many rules dealing with the legislation. Maybe you can give our viewers today a an insight as to, what the law really entails with respects to the home.
Of course, thanks for that great introduction, Joseph. So, the matrimonial home really is afforded special rights within family legislation. And specifically, we're referencing the Family Law Act, or the FLA as it's typically called. So, part two of that legislation of the Family Law Act deals entirely with the matrimonial home in terms of what it is, how it's treated in the equalization process, which overall, as an umbrella definition, is the division of property for married couples and who has the right to possess it. The definition of a matrimonial home, I find, can be rather tricky in some ways, but typically you're looking at one of the spouses having an interest in that property, the property having been ordinarily occupied by both spouses. And this is where I get into why this is a little bit tricky. So the terminology of ordinarily occupied has been referenced quite extensively in various cases, so in significant case law. And really it's come to an analysis on what really that means and whether it is important to for the parties to have ordinarily occupied the matrimonial home right before separation, or if there's a consideration to be provided for that ordinary occupation to have happened earlier on, so in earlier years before separation. And another consideration as well is for most parties who are separating or are in the process of separating, at some point they want to create a little bit of distance between one another. And so if one party were to start creating that distance, the ordinarily occupied terminology that really defines the home having been occupied as of date of separation becomes a little bit more tricky. And I'm sure I've confused a lot of people with going through that already. But you're basically looking at a property that was occupied as a family residence. That's really its purpose. So the matrimonial home is defined as such in the Family Law Act. Now, you can have more than one matrimonial home. So I've actually had quite a few cases where the parties also had a cottage that they regularly used as a family unit. For example, maybe even staying there for entire summers at a time and over holiday periods with the kids and so on. So if a cottage like that, let's say, was used at the time of separation, it can certainly also be considered a second matrimonial home. Now, that also gets tricky in its own ways. There's obviously exceptions to it. There's sort of an analysis that needs to be completed to make that determination, but the idea here is that it's possible to have more than one matrimonial home. That's what you should really take from this. Now, with respect to how the matrimonial home is afforded special rights, that is really the Family Law Act, but it only applies in Ontario. And so the special rights only applying in Ontario are outlined very well at Section 28 of the Family Law Act, if any of you were curious to look that up. So really what that means is any family homes or family property that you have located outside of Ontario will typically be treated like all other family property. And what is really recommended is, let's say you have a property in Quebec, it might be best for you to consult a lawyer in that jurisdiction to get legal advice on what will potentially happen with that property and what your rights are with respect to that property. The other tricky part of the matrimonial home, aside from the special rights that it's provided in the provisions of the Family Law Act, is that you could have, for example, a matrimonial home that's located on land that is used for another purpose. So, for example, if parties own a farm or the family runs a business from the home, it's really only the portion of the property that is regarded as necessary for the use and enjoyment of the residents. So again, going back to that idea of the family residence, that is the portion of the land that would be considered a matrimonial home. So you're getting into the nitty-gritty analysis of what portion of that particular land, let's say it's an operational farm property, would be considered the matrimonial home for all intents and purposes. And then there's other similar applications that we look at when someone is a majority shareholder in a corporation that holds property that could also be considered the matrimonial home for the purposes of the Family Law Act. So it gets a little bit tricky, but these are really sort of the basics in terms of the special rights that are awarded to the matrimonial home within the legislation that applies. Now, in terms of how that's divided or how it's treated through the process of equalization in family law, and I don't want to take too much away from my colleague Alyssa, who I think might be getting into that a little bit more in the next part of this presentation. But it's treated differently for the process of equalization than other assets that parties may have. So it's not a value that you can deduct as a date of marriage asset. So what that means is when you're completing a financial statement, you have to provide an outline of what your assets, debts, and investments typically were on date of marriage, date of separation, and current date. So when it comes to the matrimonial home, it's treated a little bit differently in that it's not a deduction that you can claim on date of marriage. It is something that is typically equalized based on its date of separation value. But ultimately, it's awarded its own special right in the process of equalization as well, if you will. In terms of some ways that you can sort of try and protect or rather determine what will happen to the matrimonial home, the very important takeaway is really getting a marriage contract done, or a prenup as it's otherwise known. And again, I don't want to overlap too much into my colleagues' presentations, but that is a surefire way to essentially protect your equity in the house, whatever may happen in the future following separation, or upon separation rather. And in terms of ownership, or the protection afforded to the home when it comes to right of possession, just to provide sort of a quick summary on that, because again, the legislation and the case law gets really deep into this specific topic. But ultimately, the home can be jointly owned. And under joint ownership, you can have a joint tenancy or tenancy in common. Now, these differ a little bit, and really, for parties who are separating, especially parties who have kids, it sort of impacts the rights of survivorship. So, in terms of, for example, if one party were to pass away, their ownership interest in the property would automatically transfer to the other under a joint tenancy, whereas a tenancy in common, it goes to a beneficiary. So that's really kind of the key difference there. But the takeaway is that the home can be owned by one party, or it can be jointly owned. What doesn't end up mattering is really your right of possession. And so you can't force the other party to vacate the home. And I'll get into that in just a minute or two to talk about what exclusive possession means. But ultimately, it means that you both have a right to reside in the home, barring an exclusive possession order, let's say, and that you have a right to your share of the equity in the house. And it really is a much easier process if it's jointly owned. So if you are both listed on title, and that is a very easy search to do with a real estate lawyer who can assist you in doing that title search to determine the type of ownership that's attributed to the matrimonial home. In terms of just typically how this is sort of dealt with when it comes to specific rights of possession. So Section 19 of the Family Law Act is where the legislation defines that both spouses have an equal right to possession of the matrimonial home. Now, and that means that even if one spouse moves out following separation, so in the event where parties are deciding to separate, or there's conflict that's protracted and it's just worsening over time, one party may make the decision of leaving the house. It doesn't mean they're giving up their right to possession of that house. So the party who's remaining in the house cannot, for example, unilaterally change the locks to prevent the party who left from re-entering the house. Now, that can be provided for by way of consent agreement or court order, in terms of the party who's remaining in the house getting an exclusive possession granted to them. The courts can grant that kind of order. It can also be agreed to on consent. In my experience, what I've seen is typically exclusive possession orders are something that a party would request if there's been instance of family violence in the home, or if it's really in the children's best interest for a party to reside in the home alone with the children, which again, in most cases that I've had, typically are linked to a history of family violence and abuse and so on. So it can get pretty dark very quickly, but the right of exclusive possession is there if you request it. And the courts have their own analysis that they go through to determine whether they will grant that right or not to one of the spouses. I don't think, Joseph, that I have much else other than some case law, but I don't think I want to confuse anyone listening in with giving citations out. But
Yeah.
if anyone has any more specific questions, or is interested in learning about some of the case law that sort of deals with these rights and responsibilities regarding the matrimonial home, I'd be happy to share that with anyone.
We can definitely put them in the show notes that will be sent to all of our Zoom viewers. Thank you, Maria. Super, super comprehensive, super insightful. Thank you. I'm now gonna switch over to Alyssa. So, Alyssa, Maria's discussed, the various ways and pretty much in summary, the really how complicated it is dealing with the matrimonial home and all the different aspects that need to be considered. But really and truly, from your perspective and how you advise clients, going through this process, going through the separation, there's three options, right? There's you're either staying, someone's selling the home, or there will be a spousal buyout, right? So maybe you can speak to our viewers on that.
Absolutely. Thank you so much, Joseph, and thank you so much, Maria. You both have done a fine job at introducing me. So, when people think about separation or divorce, the family home is often the first thing they worry about, and then the last thing they can think clearly about. It's not just an asset, it's where life happened. And Ontario law actually reflects that reality by treating the matrimonial home differently than almost any other property, like Maria said. So I want to walk you through the three main options, like Joseph said, that people usually face when deciding what happens to the family home and what those options really mean in practice. So think of it like this: staying, buying out, or selling. So the first option, one spouse remains in the matrimonial home. It's sometimes temporary, sometimes it's longer term. Under the Ontario's Family Law Act, both spouses generally have an equal right to possession of the matrimonial home during the marriage, even if only one person owns it on paper, and that surprises people a lot. So, something that's important for people to understand is that when one spouse stays in the matrimonial home, it is often treated as a holding pattern, not a final outcome. In reality, this arrangement often comes with questions like who is paying the mortgage? Who covers repairs? What happens if one spouse can't keep up with the costs? So, Ontario family law doesn't assume that the person staying in the home gets a free pass on expenses. Those costs usually become part of the broader financial conversation. What I see most often is that staying in the home feels stabilizing at first, but over time it can increase tension if expectations around costs, duration, and the next steps aren't clearly defined. There are three key things that people need to understand about staying in the home. Number one, possession is not ownership. Living in the home doesn't decide who ultimately gets its value, it just addresses where people live while things are being sorted out. Number two, staying is usually about timing, not entitlement. In real life, this option often comes up early in separation, especially where children are involved and there's a shared desire to minimize disruption. Number three, the house keeps costing money. The mortgage, taxes, insurance, utilities, none of that pauses just because a relationship has ended. So, because possession doesn't determine ownership or equalization, staying in the home is usually the most effective when it's paired with a clear plan for what comes next. Staying in the home can buy time, but without a plan, it can create conflict. Staying in the home works best when it's intentional, not when it's indefinite. So, when we talk about staying in the home being intentional rather than indefinite, what does that actually mean in practice? At a high level, a clear plan usually answers three basic questions. Number one, how long is this arrangement intended to last? For example, the plan might be that one spouse remains in the home for a defined period, whether that's until the end of a school year, until refinancing becomes possible, or until the home is sold. The key isn't the exact timeline, it's that there is a timeline. Number two, how are the ongoing costs being handled during that time? A clear plan often includes an understanding of how expenses, like again, the mortgage, property taxes, and utilities, are being managed while one spouse remains in the home. Those arrangements are usually part of the broader financial discussion, so it's not assumptions. And then number three, what happens at the end of that period? A workable plan usually contemplates what the next step is, whether it's that a buyout, a sale, or another agreed upon transition. When these questions are left unanswered, staying in the home can quietly turn from a stabilizing arrangement to a source of conflict. In other words, staying in the matrimonial home works best when it's a bridge to a future decision, not when it's a decision by default. The second option is buying out the other spouse. Legally, this usually ties into Ontario's equalization framework. So, the idea that spouses share in the value accumulated during the marriage. One thing that's often underestimated about buyouts is how many moving parts are actually involved. A buyout usually requires agreement on value, clarity on how much equity exists, and a realistic assessment of whether refinancing is possible. Even when both spouses agree in principle, buyouts can stall if lending criteria, interest rates, or income levels don't support the plan. So, from a legal standpoint and a practical standpoint, arrangements that leave one person financially stretched tend to create future disputes, and the courts are generally cautious about outcomes that aren't sustainable. A successful buyout isn't just about keeping the house. It's about whether keeping the house allows someone to move forward without ongoing financial strain. In practice, buyouts tend to rise or fall on three very real issues. Number one, what is the home actually worth? So disagreements about value are common, especially in changing markets. Number two, can one person refinance a loan? This is where many buyouts stall because qualifying on a single income is very different than qualifying as a couple. Number three, is it sustainable long term? Courts and lawyers are very cautious about outcomes that leave someone house rich but cash poor. So, wanting to keep the home is emotional. Being able to keep the home is financial. And those two things don't always line up. When we talk about buying out the other spouse, it's helpful to think about it as more than just a single transaction. It is usually a process. So, at a high level, a workable buyout plan often answers a few questions. Number one, how is the home's value being determined? So, for example, that plan might involve agreeing on a valuation method, whether through an appraisal or another mutually acceptable approach, so that both parties are working from the same baseline. That clarity alone can prevent a lot of conflict. Number two, how is the equity actually being paid out? A clear plan usually contemplates how one spouse will receive their share, whether through refinancing, offsetting against other assets, or another agreed upon arrangement. This is where timing and feasibility really come into play. And number three, what happens if refinancing or financing isn't immediately possible? In some situations, a buyout plan includes a transitional period, so where one spouse remains in the home while working toward qualifying on their own. Plans that account for these possibilities tend to be much more durable. A buyout works best when it's grounded in realistic numbers, a clear process, and not just a desire to keep the home. And then the last option is selling the home. Selling the matrimonial home is often the outcome people resist the most, and it's also the one that resolves the most uncertainty. Selling the home is often viewed as the least appealing option emotionally, but from a legal and practical perspective, it's frequently the most straightforward. A sale eliminates uncertainty around value, avoids disputes about ongoing expenses, and creates liquidity that can be divided in a way that the law recognizes as fair. It also removes the pressure of one spouse carrying a property they can't afford comfortably, which is something the courts and lawyers pay very close attention to. For some people, selling the home becomes the moment where the separation finally feels manageable. From a legal and practical perspective, selling does three things: converts emotion into clarity, it turns a highly emotional asset into something divisible and manageable. It reduces long-term conflict, so there's less to fight about once the asset is liquid. And lastly, it allows both people to reset. It creates space to rebuild financially and emotionally. Selling is not a failure of negotiation. Very often, it's a reflection of financial reality. At a high level, a clear plan usually answers three main questions. When will the home be listed for sale? So the plan might contemplate an immediate sale or a delayed sale to allow for transition. How will that decision about the sale be made? A clear plan often addresses how practical decisions will be handled, such as pricing, showings, accepting offers, and that avoids future disagreements. And then lastly, what happens once the home is sold? A workable plan usually considers what happens next, how proceeds are handled, and how each person moves forward financially. What's important to remember is that none of these options exist in isolation. Staying, buying out, or selling are all tools, and the right tool depends on timing, finances, and long-term stability. The law does provide structure, but the outcome is usually shaped by practical reality. So those are the main options people usually face when deciding what happens to the matrimonial home and what those options can actually look like in practice. I'm going to hand it over to Joseph, who is going to talk about the financial considerations when deciding to keep the property, which really builds on this.
Yes, thank you, Alyssa. I just want to add one thing, and just sometimes people are shocked to hear, but the court cannot and will not order a spousal buyout. That's really important to consider. So, if you are in litigation and you're seeking that the court will order the spousal buyout, they won't. So, moving on, now that we've talked about the legal framework, the different options around whether the home can be kept or needs to be sold, as Alyssa, integrated for me, I want to shift the focus to the financial realities of keeping the family home because, again, as Alyssa stated, and I'll be reiterating, this is really often where plans either come together or completely fall apart. And One of the biggest misconceptions I see is the idea that keeping the family home is simply a matter of wanting it badly enough. And when someone says that they want to keep the matrimonial home, the first question is not can you keep it, but really it's can you afford to keep it, both now and the long term. And under the law, if one spouse does keep the matrimonial home, that spouse is usually required to compensate the other for their share of the equity, as Alyssa mentioned. That can either be through a spousal buyout, but what that spousal buyout actually entails means what's called an equalization payment. And for many families, the home is the largest and sometimes only asset available to fund that payment. Either that or a pension, but more so the available equity in the property is really the only asset available. And practically speaking, that money has to come from somewhere, right? So it usually comes from refinancing the home, using savings, or offsetting against other assets, for example, pensions or RRSPs. And if there are no liquid assets, the house itself becomes the source of cash. And really and truly, that's where many plans really start to fall apart. Another issue people underestimate is what Alyssa mentioned is the ongoing cost of carrying costs and carrying the home after separation, right? So when we look at carrying costs, we look at mortgage payments, property taxes, and home insurance. Those are the three big umbrella carrying costs. And if the home is jointly owned, despite who's living in the home, that those carrying costs need to be shared on an equal basis when dealing with issues or expenses such as utilities, for example. That's usually the responsibility of the person currently occupying the home. And I'm not going to get into things such as uh, occupation rent. That's, really, for another discussion. But really just looking at carrying costs and the daily expenses. Um, Courts will look closely at who's been paying these expenses since separation and whether those payments are sustainable, right? So if you are currently the one occupying the home, um, various factors, considerations come into play, but it may be the case that you're not capable of currently contributing your share of the carrying costs. And however the situation does unfold, it might be the case that in order to continue meeting those requirements, especially in relation to the mortgage payments, you're not defaulting. It may be the case that the home does need to be listed for sale, right? So these are things that do need to be considered. Um, as Alyssa mentioned as well, income also matters, right? And that's both, legally and practically speaking. So even if someone is emotionally attached to the home, a lender will only look at income, debt, and credit. They're not going to look at the emotional attachment. Child support, spousal support, obligations also directly affect borrowing capacity, and it will definitely be the case that prior to any lender, whether it's accredited lender through the banks or it can be a BC lender, they're likely going to want to see the separation agreement, which or a formal separation agreement which outlines support obligations, or in the alternative, if you're in litigation, a court order. Um, Things such as variable income, self-employment, recent job changes can also further complicate things as it may raise eyebrows for the lender. But what I often see is clients stretching themselves financially just to keep the house. They're either draining RSPs, they're taking on high interest debt, or sometimes even agreeing to unfavorable support terms. And while that might work in the short term, it does often lead to financial strain down the road. And really, courts and lawyers are increasingly focused on whether keeping the home is actually sustainable or whether to simply, delays an inevitable sale, right? So these are all factors that need to be considered. And once we move past the question of whether keeping the home um, actually makes sense financially. The next issue that usually determines whether it's actually possible is financing. I'm not going to get into that right now. I will get into that, but I'm now going to hand it off to Maria. I know she specified or she spoke about it in her intro, but we're going to be discussing, or she will be discussing rather, how the impact on children and stability is with respects to any decisions that are made in relation to the home.
Thanks, Joseph. And just to sort of piggyback on what you mentioned, sort of towards the end there,
Please.
while most parties do sort of or I guess the idea is to equally continue sharing the cost of the mortgage, property tax, and insurance. I think people should be aware of what post-separation adjustments are. So in the event that, let's say, you separate and one of the spouses refuses to contribute their share, that could potentially be a post-separation adjustment to the process of equalization. So basically, anything that you've overpaid on that is not really your obligation. So to give an easier example, paying for utilities. If you have exclusive possession of the house and you're the only one living in there, you're on the hook for paying all those utilities like hydro, gas, and whatever else you might have. So if the other person is still contributing to that, absent an agreement that says otherwise between the parties, it's really the responsibility of the person who resides in the matrimonial home to pay those. So the other party's contributions could be sought after through post-separation adjustments.
Yeah, 100%. Thank you for adding that in.
I just wanted to add that, yeah.
Thank you.
So now, in terms of, again, the matrimonial home is such a big topic, and I think we're going to try and hit as many subtopics as we can today. But there is an impact to be considered on children. So if there's children that are part of the separation process, it's really important to look at how either a buyout or a sale will have an impact on their best interests and how that might also affect their stability. So the idea of the best interests of a child is something that the legislation has defined very thoroughly. It's both in the Family Law Act and the Divorce Act. And basically what the court looks at is a child's physical, emotional, psychological safety, security, and well-being. And it includes things like the child's needs, which is dependent on their age and stage of development, or if they have any special needs or specific medical diagnoses, disorders, what have you. They look at the nature and strength of the child's relationship with each of their parents, the parents' willingness to support the development of the relationship with the child and the other spouse, history of care of the child. This is a big one, the child's views and preferences. This really goes further for children who are of a certain age. So typically older children in their early teens will have their views and preferences considered much more rigorously, than a child who's perhaps 5 years of age, as an example. The courts also look at the child's upbringing and heritage. That can include cultural, linguistic, religious, and spiritual upbringing. Any plans for the child's care. So that includes, of course, not only the parenting time schedule that would have to be worked out, but also in terms of before and after school care or any third parties that will be involved in that care. The court then also looks at the ability and willingness of each of the parents to communicate and cooperate. So really to co-parent regarding the child in question. The court puts really heavy weight on any family violence and its impact when it comes to cases that have specifically dealt with that or where there's a history of family violence in the family. And so when we talk about best interests of the children, that's really what the courts, the factors that the courts are analyzing when we discuss best interests. So that brings me really to, how does that impact what we're talking about here in terms of the matrimonial home? So when I spoke earlier about exclusive possession, one of the big criteria of Section 24(3), specifically of the Family Law Act, includes the best interest of the children. That's the primary factor that the court will analyze. And then there's other things that the courts typically look at. So the financial position of both spouses. So as Alyssa and Joseph both mentioned, it really comes down to affordability in terms of whether someone is able to keep the house and buy out the other person's interest. There's the written agreement between the parties. So that's if there is any sort of marriage contract in place or any sort of domestic contract in place that spells out anything specific having to do with the matrimonial home, specifically regarding exclusive possession, for example. The availability of other suitable accommodation. This is a big one. I actually have quite a few cases where I have clients who are not extremely rich. So it's very difficult for them when they want to keep a house and they'd like to have exclusive possession so that they can change the locks because, for example, they feel unsafe if the other spouse still has access to the home, has keys to be able to get in, and so on. But the availability of other suitable accommodation, if that party wants to leave the house to be in a safer environment, let's say with the children, ideally, it really comes down to that question of affordability. So even in this scenario, if a party is just unable to afford anything else, unable to rent an apartment on a temporary basis until the home is dealt with, as Alyssa mentioned, either through a buyout or sale, typically, this is a big factor the court will look at in terms of whether a party making a request having exclusive possession of the matrimonial home, whether that will be granted or not. And then again, any violence committed by a spouse against the other or against the children. So family violence is actually a topic that has gained a lot of traction recently, and it is a very, very key and serious factor that is considered, especially when the court is being requested to make an order for exclusive possession. So the best interest of the child really is sort of the umbrella, and then all of the other sub factors are things that the courts also considers. And of course, if there's no children involved, it would just be the other factors that need to be analyzed further. But let's take the example of kids being involved in this whole scenario and having to be in the middle of the separation process. So the court will look at how disruptive the effects of a move would be on a child, for example. So not only the child's own views and preferences, which again are typically ascertained for older children, but also the effects of a potential move. So if a spouse isn't able to find another suitable accommodation, or if perhaps that would be disruptive for the child in some way, that is again a big supporting factor for why exclusive possession should be granted. And again, it's something that the courts look at very thoroughly. Now, in terms of factors that might influence the decision for a party to either keep the house or sell the house, which are really the only two options for the matrimonial home. The factors the court looks at when children are involved are things like the children's age, special needs, which again are part of that best interest test that I just went over in the Divorce Act and Family Law Act. But they also look at the need for continuity regarding their school or neighborhood. So kids will have made friends in the area. They might have been attending the same school for several years, and they have a very key support system in place with teachers they know, friends and peers that they've known for a very long time, or they might have special needs where they're working on an independent education plan with a specific support program at the school, or a special needs teacher. So these are all things that the court will look at in terms of really determining what is best for the children when it comes to matrimonial home. Now, in terms of the sale, for example, some things that, or rather one thing that the court will really look at, and interestingly, I have a case going to a motion on this very issue in about 2 weeks, but the courts can force a sale. So as Alyssa mentioned, I think she went over that in quite some detail, but the parties can either consent to sell the matrimonial home, and if it's jointly owned, one of the parties can force the sale in court, so they can seek an order for the sale of the matrimonial home. But how that impacts the children and their stability, it really becomes a question of not only what's in their best interest, but also assuming that parties agree for the home to be sold, we need to look at the timeline for that. So if parties are in discussions about selling the matrimonial home in March, let's say, kids are obviously in school until June. So there's a big key consideration here in terms of allowing a child to finish their school year, for example, before making any such big changes in their lives. And another thing we look at is also, if they're going into a new grade in September of this year, let's say that's coming up, or if they're switching schools for whatever reason and starting middle school, that's another big consideration to perhaps deal with these big changes over the summer when they're home, and allowing them some time to transition into wherever they're going to be residing next, and how their parenting schedule will work between the two parties and their respective households. The court will look at the issue of stability in the sense of, you know, some importance in keeping the children in their familiar environment and help reduce the trauma. I find in my experience that really affects more so children that have special needs or have specific medical diagnoses or disorders. That's really where the court will take a close look at whether moving them out of this environment is really in their best interest or not. And if it's not, how negatively it could impact the children in question. But one thing I did want to mention, and I don't know that many people are aware of this possibility, but as you're trying to work out perhaps a parenting arrangement because you're going through separation and you are also trying to determine what is going to happen to the matrimonial home, if you can afford to buy out the other or if it's going to be sold, etc. There's something called the nesting arrangement. So what some parties might decide to do to sort of let the children stay put and sort of help work towards that transition of eventually perhaps one party having to move out or the house being sold, so both parties having to leave with the children. It's really a process where the children remain in the home and the parents come and go. So maybe one parent is able to get a temporary lease or a rental property just for a temporary period of time, and the other parent does the same. They can still use the house and sort of come and go based on whatever the parenting schedule is. So that's something that I've seen in some cases where perhaps it's not very helpful in terms of the children's best interest to really make a quick decision on buyout or sale. And they're going to start sort of building this nesting arrangement until they're able to make a decision on what's going to happen to the home. So that's something I've seen a lot. Now, one thing that I did want to mention, just getting to the end of my my section on this topic here, but there is significant case law that really looks at it's a home the children have known, it's close to their school, it provided them a sense of stability. And what we have to remember is that even if children are emotionally attached to their home, that alone is not a reason to essentially refuse that the home be sold. So if this went to court, that's something that a judge would certainly look at very closely. And so, really, to put it in other words, the mere existence of children in the household is not in itself a sufficient basis to oppose a sale. So, if a sale is truly not in the best interest of the children, there really needs to be strong evidence advanced in support of why that is. Certainly, it's part of the factors that the court will look at when they determine the impact on the children and how that might destabilize them, for example. But just the mere argument, or rather the mere emotional argument that this is the house, the children have known for some time, and they know the school, it's very close, and it's something that they've been used to, is not really a sufficient basis to oppose a sale or really for a sale not to go through. So to summarize, it really comes down to what the best interests of the children are. But there are also the other factors that the court does analyze in terms of determining what is the best way forward in terms of the matrimonial home. Like Joseph said, a court cannot order a buyout, but we're really talking about whether there can be a buyout agreement between the parties, or consent to sell, or alternatively forcing the sale of the matrimonial home through court. And in the meantime, perhaps looking to get this exclusive possession in place. So that's really what the courts look at in terms of this particular topic. And I know that we're kind of shifting gears for the next topic, but we're going to head into how mortgages, refinancing, and debt factor in, and maybe a little bit more detail than what's been sort of presented so far, to give you guys a bit more information on that.
Yeah, thank you, Maria. So again, very, very comprehensive, very, very informative. Thank you. And I know we've discussed already today about the idea of the spousal buyout and what that entails, but I just want to touch base a little bit more with respects to the idea of how the refinancing actually comes into play. So, from a legal perspective, whether you have minutes of settlement that's been converted into a court order, or you have a separation agreement, again, from a legal perspective, the house may be yours, right? But from a practical perspective, the bank has the final say, or the lender has the final say. And a very common misunderstanding is the belief that a spouse's name can simply be removed from the mortgage. And unfortunately, that's just not how it works. So if one party is keeping the home, the mortgage usually has to be refinanced or fully discharged, and the remaining spouse must be able to qualify on their own. And refinancing often becomes necessary not just to remove the other spouse's name, but also to actually fund a buyout or the equalization payment. And this process typically requires a new appraisal, proof of income, credit checks, and approval at current interest rates, which are usually often higher than when the mortgage was first obtained. Of course, it varies, but I mean those are typically what the lender looks at. And debt tied to the home also further complicates things. So many families have lines of credit. Sometimes they have a second mortgage. They have a HELOC, which is a home equity line of credit that's actually secured against the property. So these debts don't just simply disappear on separation. They're there, and they have to be addressed as part of any plan to keep the home. So any refinancing also has to take in consideration the discharging of these debts that are tied in with the matrimonial home. And again, if we're looking at, how debt is handled after separation, right? If one spouse continues to use joint credit irresponsibly, incurs debt unilaterally, that conduct can also become an issue in property and equalization discussions, as Maria mentioned. The idea of post-separation adjustments becomes a live and well issue, and redoing those calculations to ensure that the party who may have overpaid post-separation is reimbursed or indemnified for anything that they've done, to keep everything alive and making sure minimum payments are made, or anything of that nature. And really one of the biggest risks is assuming refinancing will be approved, only to find out later that it's not. And that's why usually in most agreements, the interspousal transfer is always conditional on the other party being pre-approved for refinancing. That's usually something lawyers would like to put into any agreements, or any minutes of settlement that are again turned into a court order. Because when that happens, the buyouts fail, settlements unravel, and the parties are often left with no choice but to sell the home, right? So really in any cases of an interspousal transfer, or a spousal buyout, we'd like to see that refinancing has already been conditionally approved before we even really enter into that realm of conversation. Um, and I am cognizant of time. I know we have a couple more topics to get through, so we're going to do our best to touch as many of the topics as we can. So now I know I mentioned the need for a new appraisal, so that, just as well comes back to Maria about dealing with, valuation and appraisal essentials for dealing with the home.
Of course, thanks, Joseph. I'll try and keep it short. So when parties separate, like Alyssa and Joseph have both mentioned, it's typical either for one party to buy out the other, or for the home to be listed for sale. What typically happens when a buyout is being entertained is parties will, hopefully for the most part, agree to having a joint appraisal completed by a formal appraiser. It's usually a few $100s, at least here in Ottawa. It might be different in other jurisdictions, but it is a cost that may actually be very helpful in, of course, determining the value of the matrimonial home. So, for example, if you're getting an appraisal for the date of separation value of the matrimonial home, and you're basing a buyout on that, it becomes very important. Similarly, if both parties, for example, have been contributing to the carrying costs, the mortgage, property tax, and insurance, up to a certain point, you may want to get an appraisal for that particular date to determine what the value is for the purposes of a buyout. The difference is really when we're looking at appraisals and real estate opinions. So an appraisal is really a more comprehensive report where an appraiser will come inside the home, will take measurements, photographs, measure square footage, lot size, count number of rooms, determine any damage to the house. It's really sort of a fulsome report that outlines the current status of the home, and also does compare to others in the area that have sold or are currently listed. A real estate opinion, on the other hand, is typically free. There may be a minimal cost applied to them, but in my experience, they are typically free of charge. The upside is that they also look at comparable values in the area to determine what the potential value of your matrimonial home might be. The downside is that it's not really something binding if you were to go to court. So the court would want to see a formal appraisal report, not just a real estate opinion. But that being said, if you both parties agree on the real estate opinion and they go ahead with that value, that can be relied on for the purposes of the buyout. And of course, if the home is going to be listed for sale, it is not necessary to determine the value because the market value will be determined by the real estate agent or realtor that you both retain, who will provide recommendations on what it should be listed at, and will also, of course, entertain the offers that come in with the respective parties. So again, the recommendation here is really to opt for a more formal valuation in the form of a full appraisal to ensure that you have a more comprehensive and accurate value of the home for whatever date you're proceeding with. The difficulty that does come up, and I've seen this in some cases, is where you have competing appraisals or competing real estate opinions. And if that happens, as lawyers, we often refer to it as the experts hot tubbing, if you will. And so the two appraisers, or they can compare each other's appraisals rather. And I've actually had that happen on a file recently where the appraiser that we went with critiqued an appraiser that the opposing party had obtained earlier on. So it's very helpful for either the appraisers to come together and have a discussion or just for whoever's involved to compare the two reports. But typically what ends up happening, at least for settlement purposes, is taking the average of the two values. If they're not too far apart, that's typically the best way to proceed. But if you really can't agree on a value or on the appraisal, if there's been more than one completed, unfortunately, that does end up being litigated in many cases. So overall, the lesson really is that it's preferable and generally better for parties to obtain ideally a joint appraisal that they can pay for together. But to do that, they need to agree on an appraiser and they need to agree to share in the cost equally of whatever that appraisal report will cost. But again, the real estate opinion is an option there, especially for parties who may want to save some money and who might be willing to agree on whatever that real estate opinion is for the value of the matrimonial home. So I guess that brings us to the next topic, Joseph. I think that's negotiation strategies for the home, if I'm not mistaken.
It is. You're going to take my job. I might be out of a hosting job soon.
I don't think
Uh,
so. You're doing fantastic. So thank you for keeping us in line here.
of course. All right, Alyssa, you're up.
Okay, I'm cognizant of time and I will try to be as brief as possible. So the main thing I want to get across here is I want to talk about a few strategies that come up again and again when people are negotiating what happens with a matrimonial home and how that looks in real life situations. First strategy is interests over positions. So a position sounds like, I want the house. An interest is, but why? So once you identify whether the interest is stability, affordability, finality, more options usually start to open up. So is it stability? Is it financial security? Or is it emotional closure? What's interesting is that two people can hold the exact same position, wanting the house, but for completely different reasons. One spouse might want the home because they're worried about uprooting the children, like Maria said, while the other wants it because they're afraid of not being able to afford housing elsewhere. So once interests are identified, negotiations often become much more flexible because the solution doesn't have to be limited to one outcome. When negotiations get stuck, it's often because people are negotiating positions instead of interests. The second strategy I want to talk about is timing as a negotiation tool. Timing is one of the most powerful and overlooked negotiation tools when it comes to the matrimonial home. People often think the disagreement is about what should happen to the home, when in reality, it's about when. Ontario courts regularly deal with questions about whether a home should be sold immediately or at a later time, depending on the circumstances. Is it immediate versus delayed? Is it a transitional arrangement? Is it future triggered outcomes, like should a buyout or sale happen once certain conditions are met? So, for example, one spouse may not qualify to refinance the home immediately, but could reasonably do so in 6 or 12 months once support arrangements are settled or employment stabilizes. So, of course, timing only works when it's paired with clarity. Indefinite delays tend to increase conflict, and we don't want that. The third strategy I want to talk about is that the home is rarely negotiated alone. So, another important negotiation strategy is recognizing that the matrimonial home can sit at the center of a much larger financial picture. Under the Family Law Act, the matrimonial home is rarely considered in isolation. It's usually interacting with support, debts, the overall equalization, like we've already said. So what this means in reality is that negotiations are often trade-offs. So one spouse keeps the home while the other keeps more liquidity or takes on fewer ongoing obligations. Effective negotiations don't just aim for identical outcomes for each party. They aim for outcomes that each person can live with. And the fourth strategy I'd like to talk about is managing emotions without letting them drive the outcome. Negotiations around the family home are often happening while people are very much grieving, and Ontario courts recognize that emotional context, even while focusing on the practical outcomes. So, negotiating the matrimonial home, it's not about winning or losing, it's about balancing emotion, timing, and financial reality in a way that allows people to move forward. So, again, cognizant of the time, before I move on to the next topic, which I intended to speak about, I don't know if Joseph, if we just want to skip that altogether, and if you want to talk about how the courts tend to make these types of decisions.
Yeah, sure. I think that might be best. I mean, if neither party can keep the house, right? There's you either sell it or we let the court get involved. So I mean, I think that's where my topic sort of starts. So thank you, Alyssa. Um, so when the courts may intervene, so ultimately courts do not want to manage your property for you, but they will step in when they have to, right? If litigation's been commenced and application's been commenced, then um, that's what will end up happening unless the parties can agree otherwise through settlement discussions. And that goes without saying that courts prefer that parties resolve issues surrounding the family home through negotiation or agreement, right? They don't want to ever have to step in. But they will intervene when there is deadlock, financial risk, or really ongoing prejudice to one party, or more importantly, the children. And really, the most common form of intervention is an order for sale, and that's done through the Sale and Partition Act. And if neither party can realistically buy the other out, the court may order that the home is to be sold, even if one spouse strongly objects. And I know Maria spoke about that. If there's both parties on title under the Partition and Sale Act, they do have the option to force the sale of the home through the court. Maria also recommended, or sorry, excuse me, she also spoke about the other remedy of exclusive possession. I'm not going to get into that, but courts may also make what's called a preservation order, and the preservation order will be there to prevent one party from selling, refinancing, or otherwise encumbering the home without consent. So that's another way courts step in. Um, what courts will not do, and I know we've discussed this in detail, everyone's really spoken on this, is that they won't make decisions based on emotional attachment, and they won't force lenders to approve financing. That's not their job, and they won't do that. And what I've seen, I'm sure Alyssa and Maria can also maybe agree to this, is that increasingly courts have emphasized financial realism and timely resolution. I think that's the bottom line into how they wish to operate. And, prolonged joint ownership after separation is discouraged, especially when it fuels conflict. And Maria's talked about different ways in which we can reduce conflict, whether that's through exclusive possession, whether that's through a nesting arrangement, whether that deals with the immediate sale of the home, parties jointly retaining an agent to getting the house on the market so they can get some liquidity, cash in their pockets, and try to eliminate as much conflict as possible. And really, at the end of the day, if the financial, lending, or tax realities don't align, parties are often forced into negotiations that they didn't initially expect, right? And while all of these issues are complex and they're heavily financial, they don't exist in a vacuum. I think that's, well and clear what we've all discussed with today. And that brings me to our closing. So thank you so much to our viewers on Zoom, to our viewers on YouTube for tuning to Family Law Now After Hours. After this session, if you are joining us via Zoom, a brief survey will appear, allowing you to share your comments and suggestions for future topics that you'd like us to explore. As always, your feedback is greatly appreciated. Again, since you've made it this far, you'll know that you are able to now book to take advantage of this opportunity for a complimentary 20-minute consultation with one of our lawyers here at the firm at Russell Alexander. In order to take advantage of this, please contact our intake team at intake@russellalexander.com. It's two S's, two L's, and mention our after hours series to schedule your appointment. Registration is also now open for our next event, which is next Tuesday, Divorce in the Family Home. Nope, that's today. Our next topic next week is, sorry, Love is in the Air. Why smart couples sign prenups in Ontario. That is our next topic for next week. And all you have to do to register is just go to russellalexander.com/family law now. Thank you again so much to our panelists, both Maria and Alyssa, for sharing, their insights today, both extremely knowledgeable, and, so comprehensive. Thank you so much. I know you're doing such a service to our viewers today. And thank you again, the viewers, for tuning into Family Law Now After Hours. Have a great night, everyone.